I'm Tamara Monosoff, and I'm the founder of MomInvented.com and my new mentoring and training website, TamaraMonosoff.com. If you have an idea for a product and it's been percolating in your mind, then probably one of the first questions that you're wondering is, how do I protect my idea? That's why I'm delighted to introduce you to my good friend and special guest, John Merchant of J. Merchant Law. John is a business law attorney as well as an intellectual property attorney. John, thanks so much for joining us today.
It's great to be here.
John, one of the very first questions that we have is, what is the difference between a patent, a trademark, and a copyright? And so I'm wondering if you could start first with, what is a patent and when do I need one?
Well, patents generally have to do with inventions, which are novel articles of manufacture or machines or compositions, processes. They can apply to a portion of the product you wish to sell, or they can apply in some cases to the entire product. But generally speaking, they have to be novel and they have to be non-obvious over the prior art. The technical definition for a patent really is that it's a government grant that allows the owner to exclude others from making, selling, or using the patented item for the term of the patent. And the terms of the patents are limited. So it really is the most valuable protection when it covers the particular aspect of your product which makes it most competitive in the marketplace. And there are basically three types of categories of patents. There's the utility patent most people think of. The thing has to do with the function of the item.
John?
Yeah.
Can you say, for some reason you cut out for a second. So you said the first one is the first one you said is a utility patent.
Yeah.
Okay.
Okay. The first type is a utility patent. Mm-hmm. The utility patent has to do with the function of an item. So it pertains to things that are novel and new about the article. It can have that has to do with how the article works. So a good example would be, say, Velcro hook and loop fasteners, or a particular new way of opening a wine bottle. It has to be a new type of function. And the other type of patent is a design patent, and that pertains to the aesthetic aspects of the product that are not dictated by function. So you can think, for example, a particular shape of a lamp. The shape isn't dictated by the function. It still operates as a lamp like any other lamp, but the base of the lamp might be of a particular shape that is attractive and valuable in the marketplace, and that can be design patented. And then the third category are plants, and patents apply to particular types of plants, asexually reproduced plants like plants that can be reproduced through grafts or cuttings and things like that.
What about things like that is a chemical composition, like shampoo or cosmetics? Would that fall under a regular utility patent, or how does that work?
It can. If it's a new composition, if it creates a new composition, a new type of, like for example, many drugs are patented. So it has to do with the way the chemicals work together. And if that creates something that is novel and not obvious over the prior art, then it can be patented. But there are other ways to protect things like formulas and those types of things. But generally speaking, yes, you can get a patent on a new type of formula or composition.
Great. Now, you've mentioned prior art a couple of times, and so I would love it if you would explain what you mean by prior art.
Well, prior art it's a fancy term for what has come before. In other words, what is relevant to the product that you have, and what is the relevant prior things that people use to do what you're intending to do with the product. So if it's a lamp, then the prior art would include all the different types of lamps that occurred prior to or were placed in the marketplace or known prior to your invention.
Great. You know, one of the things that I've learned over the last 10 years is how powerful trademarks can be. And I've found them to be really useful tools. And so I wanted you to explain to everyone what a trademark is, if you will, and then when it would make sense to apply for a trademark.
Okay. Trademarks are source indicators. So trademarks basically indicate to the consumer the source of the goods and services that are being offered. And trademarks are usually things like names or logos. They can be symbols, like the Mercedes-Benz symbol. To some extent, they can be colors. The Louis Vuitton red sole on the shoe, the red color on the sole of a shoe, that is actually acts as a trademark because it indicates to the consumer that those shoes come from Louis Vuitton. Even sounds can be trademarked. For example, the NBC chimes, they go da-da-da, something like that. That can be a trademark. But generally speaking, when people talk about trademarks, they're really talking about trademark registrations, which means that someone has applied for registration with the trademark office and obtained a sort of certificate that allows them to, it strengthens their rights geographically, really.
Well, I think it's interesting too, just using my Mom Invented brand as a trademark, that we have the brand, which is the logo and the look and feel of the trademark, but then also there's a word mark, so it's the Mom Invented words. And so can you talk about those two different aspects, just so that people can start thinking about their own brands and logos that they want to create?
Right. Well, the brand, oftentimes the logo will include various aspects. So, for example, there's the design aspects, the color, the shapes that you're using. Those can indicate independently of the words the source of the goods and services. And a lot of times, a particular design will be used without the words to indicate where the product comes from. And then there's the words themselves. And the words oftentimes are the name of the company, or it could be the name of the product. And those words can be registered independently or used independently of the design aspects as source indicators. When you're talking about registrations, a lot of the time you're talking about what the scope of the trademark rights are. And when you're trying to prevent others, basically, with trademark rights, you're trying to prevent others from pawning off their goods and services as yours. So the focus is about whether or not the consumer might be confused by two different companies using the same or similar marks for the same types of goods and services. So generally speaking, you want to create a mark that has some novelty, that isn't confusing to the consumer, and that you want to use that mark in relation to the goods and services to develop this relationship between what you're using, either a design, a sound, a color, whatever, and the goods and services that you're providing.
That's really helpful. Tell us now, if you will, about copyrights and how they're relevant to what we're working on if we're bringing a product to market, or just explain to us how we could use a copyright if we even need one.
Okay, copyrights, generally speaking, have to do with a particular new type of expression, or a new expression fixed in some sort of media. So a classic example would be books or paintings or designs that can be placed on top of a product and removed from a product, don't have anything to do with the function of the product, but are basically aesthetic designs that make it attractive. Those things can be subject of copyrights. And like trademark, a lot of the time people are talking about copyright registrations. When they talk about copyright, they're talking about when something is copyrighted, they're saying, Well, I have a copyright registration, which is a process of obtaining a certificate from the Copyright Office, saying that you have met all the criteria for having a copyright. But really, trademark and copyright, they are automatic rights. So trademark rights are created at the time you use the mark. Copyrights are created at the time you put the expression down in some sort of tangible medium. So the registrations are something in addition to the rights that you have, and it strengthen the rights that you have. But getting back to what copyrights are, they often have to do with writings or particular designs and films and videos and things like that. And they can be part of your product or they can be your entire product. And so you have to think carefully about these various tools, patent, trademark, copyright, as to which apply to your product. And then oftentimes a number of them will apply. You could get a design patent on a shape. You can also get a copyright on a shape in certain circumstances. So I don't have time to go into all the minute differences between the various things, but generally speaking, you can understand what the purpose of these tools are and how they might apply to your product and see what might work for you.
John, thank you so much for joining us.
Happy to be here.
I hope you'll join us for our next session with John Merchant of J. Merchant Law, because he's going to talk to us about something very important that does impact all inventors. And that's a new law that went into effect this year in March 2013. And it's called First to File rather than First to Invent. And John is going to explain what the law is and how it's relevant to you. I hope that you'll join us. Thanks so much.